A very good afternoon and welcome back to the Analyst of Vajiram and Ravi, where we bring to you detailed discussion of important articles from both the Hindu and Indian Express. Today is 8th of December, and what are the important articles? Let's have a look. The first topic is about a landmark judgment in the India which has completely changed the course of constitutional interpretation. This is the Kesavananda Bharati case, which is in news because a 5-minute video on the same has been released by Supreme Court to commemorate the 50th year since this judgment. Then in the second topic, we will read about, in light of the ongoing proceedings in Supreme Court regarding the constitutional validity of Section 6A of Citizenship Amendment Act, we will read about the Assam's illegal migrant case. Then, in the third topic, we will read about ethanol, a very important biofuel for India, and we will also read the national policy on the same. Then, from prelims point of view, we'll be reading about two things. First, the OPEC Plus, which is the oil cartel of the world, and finally, a very, very rare genetic disorder, which is in news. This is the Pompe Disease. So, let's get started. So, our first topic is a very important one. This is the Kesavananda Bharati case. This is running into the context of the 50th year since the judgment came out. The judgment came out in the year 1973, which completely changed the course of the constitutional interpretation in India. And the year 2023 marks the 50th year of this judgment. And to commemorate that, Supreme Court has recently made a video available on it in order to increase the awareness of the citizens regarding this judgment, and it has been made available in 10 languages. Now, this is a very, very important article from examination point of view, so pay your kind attention to it. Now, whether you are an UPSC examination aspirant, or whether you are a law grad, or whether you are an aware citizen of India, you must have at least for once came across the significance of Kesavananda Bharati case, which, by the way, is the longest running case in India. Its jurisdiction, its proceedings lasting up to 68 days. And not only that, it heard petitions and it heard provisions and read across multiple constitutions of over 70 plus countries. And it was also heard by the largest ever constitutional bench of the India, comprising of 13 judges, 13 Supreme Court judges. So definitely this was a historical judgment which completely changed the course of constitutional interpretation. So what was this judgment? Before understanding that, let's first understand the background in which this case will come. So the background is where the India has got the independence, and India has got independence from the colonial rule. So when the independence came, all the states rushed into following up or pursuing the socio-economic justice, which was one among the duties directed onto them by the Constitution of India, where by the part 4th of the Constitution, which is DPSP. So there were two basic provisions of the Constitution, that is Article 39B and Article 39C, which respectively told or gave direction to the state that it should make the endeavor in order to, first of all, promote the equitable distribution of the resources among the citizens of the India, and second, to prevent the concentration of the wealth. Now, these two things states had to perform. So it started pursuing many reforms. The most important reform were the land reforms. Why land reform? Because the concentration of wealth is the topic here, and the concentration of resources was best seen in the case of land, because of the colonial policies like zamindari system, tenancy system, etc., which facilitated for the concentration of huge pockets of land into fewer pockets or into fewer hands. So therefore, the first target was to bring about the land reforms in order to facilitate Article number 39B and Article number 39C. So following what all the states were doing, Kerala government also followed a particular thing, a similar thing. So Kerala government introduced the Kerala Land Reforms Act in 1963 in order to facilitate the socio-economic justice and in order to provide socio-economic growth in the state. So this is a land reform act. What will it be doing? It will be limiting certain land ownership rights of the citizens. This land ownership right was conferred on them under Article 31 of the Indian Constitution. This was one among the fundamental right which conferred on to the citizens of India that they shall be having the right to private property. So this was somewhere compromised by this Kerala Land Reform Act, where the state started taking away the land or restricting the right to property of the citizens. So on the basis of this ruling and using this particular act, Kerala government also took or usurped some of the land of the Ednir Mutt, which was situated in one district of Kerala. Now, this Ednir Mutt, as you can see, that this is a religious mutt. Here, religious things will be going on. Here, propagation, profession of the religion will go on. And once the land of this mutt is taken away, what will happen eventually? That as a result, the income of this mutt will go down, and as a result, the profession of religion, the propagation of religion and the practice of religion, all of that will also be compromised, which is conferred onto the citizens of India under Article 25 and under Article 26. So till now we have seen that by the very promulgation of the Kerala Land Reform Act, there are three fundamental rights which have been compromised. One, Article 31, Article 25 and Article 26. Now, in order to do away with this injustice, lead was taken by the head of this Ednir Mutt. His name was Kesavananda Bharati, who challenged this very state legislation in the court. So now the legislation came where in March 1970, Kesavananda Bharati will file a case against the state of Kerala, and therefore this case will be brought to the Supreme Court. Now, before understanding the writ petition and what all happened, what were the outcomes and what were the arguments, we will understand what was the ongoing power tussle. Because even before this case was brought in the eyesight of Supreme Court, there were previous tussles going on between the two very important pillars of democracy, that is the legislature, the Indian Parliament, and the judiciary. So what was this power tussle? Let's have a look. So from this timeline you can see that ever since the Land Reforms Act started promulgated in India, there were tussle as to how we can balance the DPSP that is given under the DPSPs, particularly 39B and 39C, and how to balance it with the fundamental rights like Article 14, Article 25, 26, 31, etc. So in order to have a balance between both of them, a huge judgment ran across the course of time ever since the independence. It all started with Shankari Prasad case and then Sajjan Singh case. In both of the cases, Parliament said that we can amend any part of the constitution, including the fundamental right, which means we can curtail your Article 31, the right to property, if we want to progress, if we want to pursue something which aids the socio-economic justice in the India, for example, land reforms. Then Supreme Court become very active regarding this, and Supreme Court in 1967 in its Golaknath judgment gave a very extreme opinion. Supreme Court interpreted the constitution by saying that Article 368 does not give Parliament the ultimate right to amend anything that comes in its way. And secondly, it said that you are completely prohibited to amend the fundamental rights that are given to the citizen of India. So in this case, you can see that Supreme Court took a very extreme stance. Now the Parliament, enraged by this, said that how can you take away a right to amend the constitution? We also have got our own parliamentary sovereignty. So therefore, Parliament came up with three responses. First, in the form of the 24th Constitutional Amendment Act, in which Parliament said that we are allowed to amend about any provision given in the Indian Constitution. In the Constitutional Amendment Act of 25th, Parliament said that under Section 2 and Section 3, it was highlighted that Parliament has the power to curtail the right to property given under Article 31 of the Indian Constitution, along with due compensation to be given to the victim. Now, this particular compensation will not be decided by the court, but by the Parliament itself. And secondly, under Section 3, it said that wherever Article, that is DPSP's 39B and 39C comes in, the other fundamental rights like Article 14, 19, they go out. So these were the two cases that were brought forward by the 25th Constitutional Amendment Act by the Parliament. Now came the question in front of Kesavananda Bharati case along with the Kerala legislation that first of all, can the Parliament amend the fundamental right? Should it be given the power, or it should be completely curtailed just as how Golaknath case did? Or should it be given ultimate power to amend any provision of the constitution? And if at all it is given a power to amend the fundamental right or the constitution, to which extent it should be given the right? So the question on the extent and the question of amendability of fundamental right was the main theme of debate in the Kesavananda Bharati case. Now, in the Kesavananda Bharati case, now the scope will broaden. The scope will broaden not only to deal with the Kerala Land Reform Act, but also the previous legislations, that is, the interpretation of Golaknath case of 1967, interpretation of the amendability powers given to Parliament under Article 368, the validity of 24th Constitutional Amendment Act, 25th and 29th. So these are the scopes that, or these are the powers, these are the matters that Kesavananda Bharati case was going to examine. So Supreme Court constituted the largest ever bench comprised of 13 judges, and when the result came, it came with a 7:6 majority. So with that margin, what happened? What was the outcome of Kesavananda Bharati case? First and the very important outcome was that it upheld the validity of the 24th constitutional amendment, where Parliament said that we are able to amend about any provisions of the constitution. But definitely, it needed to be limited as well. So in order to put that limitation, the basic structure doctrine was for the first time ever introduced in the Kesavananda Bharati case, where it said that Parliament has the power to amend any or all provisions of the constitution, but with a condition that it should not be compromising with the basic fundamental principles of the constitution. So therefore, this fundamental provision or these principles will be enlisted in the form of basic structure, and they will evolve according to the judicial doctrines or according to the judicial proceedings. This was the first thing. Second, it also had to talk about the Golaknath case. So this was for the first time that Supreme Court admitted its own mistake and overruled the entire judgment of Golaknath case, where it said that Parliament does not have any right regarding amendability of the constitution. Here, Supreme Court completely overruled and gave powers to the Parliament under Article 368 and said that it can completely amend fundamental right also, given the restrictions of the basic structure of constitution. Then it also upheld the validity of 25th and 29th amendments. Now, what did 29th amendment say? 29th Amendment basically brought some of the land reforms into the bracket of 9th schedule. 9th schedule is that blanket which protects the laws which are in it from the judicial review. Now again, this violates the basic structure of the constitution, because one of the feature of basic structure is to have judicial review of about everything. So therefore, in order to ensure that, Parliament said that, Supreme Court said that 25th and 29th amendments, though they are completely upheld, but they are not justified when it comes to curtailing the powers of judiciary or protecting it from judicial review. So yes, there's no blanket protection to them. They are still under the judicial review. They are still eligible for judicial review. And therefore, it finally gave the basis for the ultimate judicial review in the India. Interestingly, Kesavananda Bharati lost his case, but the democracy won. And therefore, this is one of the cornerstones of the Indian Constitution, which protected not only the fundamental principles of the Indian Constitution, but also the rights of our citizens. So coming to the next topic, this is Assam's illegal immigrant case. So what is the context over here? There are running proceedings going on in Supreme Court, and Supreme Court has recently issued order to the Home Secretary to file affidavit regarding the details of the inflow of the illegal migrants before 11th of December. And Supreme Court, the CJI of India, has also said that it is not justified for everyone to settle in India. So Supreme Court has basically put a red flag as to stop the illegal immigration in India. So let's talk about this particular case. It deals with GS3, GS2 part of the syllabus. You can read the different portions of the syllabus over here. Now, what is this particular case? Let's have a quick look. See, this is a case of illegal immigration. Illegal immigration, or what is illegal migrant? So first of all, let's understand the difference between immigration and migration. So whenever a person tries to come to another place away from their own homeland in the search of better opportunity or to live there, to reside there temporarily, then that process is known as migration. But if a person comes with the intention of permanently settling down, then that process is known as immigration. And in this case, we are talking about illegal immigration in India, which has occurred in Assam and which is the case of matter going on in Supreme Court. How does Indian Constitution or how does India define illegal immigrants? So illegal immigrants are those which enter the country without the valid documents that are prerequisite that are given by the government of India. Second, those people who are though entering with a valid document but stays beyond the permitted time limit. What is this time limit? That is the entire scenario over here. That is the entire case of conflict over here. Section 6 of the Citizenship Act says that the cutoff date is 19th July 1948. So everyone who has came before that will be given the citizenship of India, but anyone who's coming after that from Pakistan as a migrant will be considered illegal migrant. Then another introduction was done in the form of Section 6A in order to realize the Assam Accord of 1985. So in order to realize the Assam Accord, which is basically a tri-party agreement between the center, the state government of Assam and the students union who were leading the Assam movement in order to do away with the illegal immigration in Assam. So a tripartite agreement was set between them and three of them agreed that we will set up a cutoff date. This cutoff date will signify that all the people who are coming before that will be accommodated in Assam. They will be given the right of not citizenship but given the right of ordinary residence. But after whoever is coming after 24th March 1971, they will be considered as an illegal foreigner in the state of Assam or in the nation of India. So basically, Section 6A has laid down a separate and a different cutoff date as compared to what has been observed pan-India, that is under Section C. Here the cutoff date is 1971. And previously, the cutoff date was for the rest of the India, it is 1948. And here is where the conflict begins. So what does Section 6A of citizenship talk about? According to the petitioners who have filed the cases, 17 cases are going on in Supreme Court regarding this matter. The petitioners are saying that this particular section is the beacon of the illegal migration in India, because it provided flexibility to the people who came at the later date after 1948. And the Citizenship Act actually divided the immigration into three timelines, three periods, that is, people who are coming before January 1st, 1966. Kindly pay attention to this. People who are coming before 1966, they will be considered as ordinary citizens. They will be conferred all the rights and obligations that are given to the citizen of India. People who are coming after that, that is from January 1st, 1966 to March 25th, 1971, they will be given the same status of ordinary resident, except that for the next 10 years, they will not be able to vote. So, a limited amount of liberty was taken from them. Next, or the rights were taken from them. And finally, the last timeline that was set in regards of the Assam Accord, the date of March 25th, 1971, after which whoever is coming into Assam will be considered as illegal immigrant. And here lies the issue. Interpretation of the Section 6A call for the issue. What are the issues? First of all, petitioner says that it actually encourages foreign infiltration in India. Because looking at the precedents, what can you see? That government has eventually liberalized, especially in this particular time period from 1966 to 1971, government has gone liberal on the people who were erstwhile declared as illegal migrant. So the petitioners now say that this is a further threat to the indigenous right, because the further influx that is going on, especially, in the Assam NRC, which happened a few years ago. This was National Registers of Citizen, and the population was counted, and about 13 lakh people out of the 3 crore registered people were declared to be living illegally. So where will these all people go? So the petitioners fear that even this particular clause will be further liberalized for them, accommodating them back into the state of Assam and giving them the right of ordinary residence. And this is the main issue with them. The next is, while there is huge influx which has already been there in the form of illegal migrations, this also threatens the very cultural identity of the Assamese people, because it can also pose a threat to their social identity, cultural identity, economic identity. And then it also says that Assam government and the central government in the case of Assam is following a different policy altogether, because the cutoff date for the rest of India is set one, and for the Assam it is set different. So why is it so? It says that Assam is subjected to different citizenship regime, which is completely illogical and unfair. So this particular date, the March 25th, 1971, is also not recognized by the petitioners. They say that it is arbitrary, it is unjustified, it is discriminatory, and end of the day, it was a resultant from the violation from the violent actions that were pursued by the Assamese movement led by the student union. And upon seeing these violent movements, what the government has done, government has set about any date, which is very, very random, very arbitrary, makes no sense. So therefore, this particular section, the constitutional validity of the same is under the proceedings of Supreme Court right now. Now, what in general are the impact of illegal migrations or illegal immigration, which has also been duly recognized by Supreme Court yesterday? So Supreme Court said that, first of all, it puts a strain on the already constricted resources of the land. For example, in Northeast, where developmental parameters are already poor, we do not have adequate healthcare or social factors or educational facilities. There, when we are putting more population burden in less amount of resources, what will happen? This will lead to deprivation of a lot many people, discrimination in the allocation of resources, and eventually led to the feeling of marginalization among the people, and this will now start creating conflict between different communities. And conflicts will give rise to the threat to law and order. Law and order threat will eventually, it is a resultant, first of all, of the deprivation, of the lack of representation that the people feel. They are frustrated and they do not have enough adequate political representation as well. So therefore, in the lack of it, they would want to channel their frustration through other means that are rather illegal. For example, they would turn to radicalization. They'll be very prone to radicalized tendencies like terrorism, Naxalism. They will also take up arms and pursue militancy, as seen in the case of Nagaland, Manipur, etc. And also, due to lack of economic opportunities, they may settle down for alternate economic avenues like smuggling, especially in the case of Northeast, where the smuggling can be very, very easily aided due to the porous borders because it is mostly forested, and second, because smuggling is more prevalent in the areas like Bangladesh and Myanmar, and also lies the Golden Triangle, which is the hub of drug trafficking in this region. So therefore, this area is already very prone to smuggling, and such influx of migrants or such unsustainable influx of migrants further aggravates the situation. Then it also poses a threat to the security. A lot many personals have to be deployed over here, which compromises with the other security challenges of the entire nation. It also leads to loss of livelihood and property, etc. And also, it changes the demographics. Now, this pointer has also been highlighted by the Supreme Court, by Chief Justice of India, who has said that, especially in the case of Northeast, where it has been seen that a lot many influxes happened. So, if you observe the map, if you observe the geography of Northeast, the influx is happening not only from the Madheshis of Nepal, but also from the Chakma Hajongs of Bangladesh and also from the Rohingyas of Myanmar. So, a lot of people are coming in the form of illegal migrants in the state of Assam of late, and especially generally in the entire northeastern states. So this is also changing the demographic, that is the composition of the population. Therefore, there is a threat to the cultural identity. There are rising communal tensions. For example, the violence of Kokrajhar in Assam was a resultant of the clash between the indigenous communities who feel deprived, who feel that their homeland and their home resources, which they are entrusted upon by their ancestors, have been taken away by the people who have unduly came to their land. So these conflicts are also seen very much in news. So what can be the way forward once we have understood the impact? First and foremost, just as our government is following the One Nation, One Policy scheme, should also follow a One Nation, One Date scheme, so as to set a uniform date of the migration, a cut-off date for declaring illegal migrant across India, not leaving Assam apart. So therefore, first of all, we need a national common date. Second, multilateral cooperation among the different neighboring states like Myanmar, like Bangladesh, Nepal, etc. is also needed, so that we can take care of the refugees, we can rehabilitate them properly, and we can also address the issue of ongoing migration, illegal migration. And then we also have to perform effective border management by deploying technologies, etc., in order to enhance our surveillance capabilities and also ensure that socio-economic development, especially of the Northeast, via infrastructure development, socio and economic health parameters, etc., all of that should be developed so that we can bring socio-economic development, so the feeling of marginalization can be lessened up, the conflicts can be lessened up. So these can form a very good way forward to the situation. Now let's talk about ethanol. Now, ethanol is in news because Ministry of Consumer Affairs, kindly note down the name of the ministry which is doing this. Ministry of Consumer Affairs has directed the sugar mills and distilleries to not use the sugarcane juice or syrup in the ethanol year 2023-2024. Why ministry has done this? Because of late, due to the diversion of the sugarcane juice in the ethanol plants, the overall price of the sugar that we consume has seen an inflationary trend. So in order to safeguard sugar from the inflation, it has been said that this diversion should now be avoided at least for 1 year. Okay. Now, this is very important topic because ethanol has been a favorite topic of UPSC, has asked about it in the prelims examination. We'll try to solve this question later. But first, let's read about ethanol, the very prospective, promising biofuel. Now, ethanol, as we know, is also chemically known as ethyl alcohol with the formula C2H5OH. Now, this is very famously used as a biofuel because of its purity, or because of its lack of impurity. It actually is a kind of alcohol which is also consumable. It is also edible. Now, this alcohol has got 99.99% of purity, so which enhances its blendability with gasoline, and therefore ethanol makes a very good fuel which can be blended as a biofuel. It is a biofuel, it's a green fuel which is of non-emission in nature. Second, it can be blended easily, and third, because it performs high purity, it gives high purity. Therefore, the greenhouse gas or the amount of footprints of the polluting gases, that is also lessened up in the case of ethanol. Now, why do we resort for ethanol and not methanol? Methanol, that is CH3OH. Now, despite methanol being very easy to be made or manufactured, this is more toxic. And second, this is more inflammable as compared to ethanol. And the worst thing, it is very harmful, very hazardous for consumption. In fact, if we take unregulated exposure or dosages of methanol, then it may lead to death as well. So therefore, being more toxic, it is less reliable as compared to ethanol, which is more safer and more widely available fuel. Now, what is the need of resorting to a biofuel, for example, ethanol? The need, first of all, is that we need to finish up our blending targets. Blending targets, that is under the ethanol blending program, also under the national policy on biofuels that is given by Government of India in 2018, according to which we have to set or we have to fulfill certain blending targets, and ethanol has been chosen for that, to be blended with petrol and diesel. And second, to reduce the dependence on the fossil fuel. Fossil fuels are a menace. First of all, they not only cost us higher bills because we are import dependent and the prices fluctuate of late, therefore leading to increase in the amount of total current account deficit that India faces, and also because it is said that using a particular amount of blendable ethanol will be able to save our bills up to $4 billion, and that is a great amount. Second, it will help us in fiscal consolidation. Then it will also help us to reduce the emissions. Emission reduction is one among the Panchamrit targets that has been adopted by India, that are basically the revised NDCs of India that were taken up in COP26, and which has promised that by 2030 we will be reducing our emissions to total of 1 billion tons. In order to do that, we need to have interventions in the form of biofuels. One is methanol. Then it also performs waste management purpose. Why? Because the ethanol policy says that the ethanol will be converted or will be manufactured using starch-based the feedstock, or that kind of feedstock which is not consumable or which is spoiled feedstock in the form of stems or the spoiled wastage, etc. So therefore, it will also facilitate waste management, and not only that, it will also help the farmers to double up their income, increase the income by diversifying it. Now they can also sell their stocks, the surplus grains and their agricultural biomass with some cost, and that is very, very important to double up their income. So therefore, ethanol is not only helping us with the food security, with waste management, with environmental security, but also with the income security of the farmers. Now, what are the fuels? This is very important from prelims point of view. So what are the different types of ethanol fuel, or rather biofuels. That depends upon the sources which are generating this fuel. So for example, I'm taking a source, you know that ethanol will be created using food. Now if that food, or if that part of the food is a consumable content, for example the sugarcane, the cassava, or for example the wheat, the corn, sugar beet, potato, something which also ensures food security of the nation, a fuel that is created or manufactured using these sources is considered as a first generation fuel. The positive thing is it is very efficient to be created because the starch content is very high, easy to be fermented, and easy to be fermented, which means a lot many amount of ethanol can be generated. But the bad thing about it, about the first generation one, is that it compromises with the food security of India. The potato that I can eat is rather going in ethanol refineries. So therefore, it compromises with food security. So the second generation is more advanced one, which eventually utilizes the unedible or the non-edible part of the food. For example, the stacks, for example, the leaves, for example, the soil waste. So when you use that and when you perform thermochemical conversion, so a technological intervention is taken over here where this particular stock or this particular unedible part, for example wood, for example crop residue, etc., they will be converted into ethanol in the form of or with the help of a technological intervention. And then finally the third generation does not require any kind of intervention from the food security related products. For example, it uses algae. So algae will not only help you to secure the food security of the nation, but producing or taking or manufacturing ethanol from algae will also ensure that you are not compromising the water security either, which is otherwise taken to feed off these crops. So this was about the third generation one. The bad thing about the third generation biofuel is that in order to enhance the production, we would require a lot many fertilizers. So that will have an impact on the environment because the fertilizers will be detrimental for the environment. So this is the negative impact of this. And also let me briefly tell you about the fourth generation biofuel. Here, genetically modified crops will be created such that they suck the carbon, such that they have a negative carbon emission, which means they not only produce ethanol, but they also help in carbon sequestration. They absorb carbon dioxide from the atmosphere. Therefore, they not only don't release at all, but rather they absorb the excess carbon dioxide. That is about the fourth generation biofuel. India currently is pursuing the first generation biofuel because of the increased efficiency in the outcome. Now, let's quickly talk about the policy, that is National Policy on Biofuel. Now guys, please remember that this is promulgated by the Ministry of Petroleum and Natural Gas. Initially we saw that the Ministry of Consumer Affairs, Food and Public Distribution has made this particular announcement, but here we will see that the entire policy, the broader policy, is under the Ministry of Petroleum and Natural Gas. The nodal agency for the production of fuel grade ethanol is under the Department of Food and Public Distribution of the Ministry of Consumer Affairs. So I hope that clarity is now with you. The policy of biofuel says that we need to achieve a blending of about 20% by the year 2025. Initially it was 2030, but can you see the trend over here? Can you see the advancement of ethanol blending? We have reached from about 1.6% in 2013 to nearby about up to 12% of blending in the year 2022. So because we are increasingly blending the petrol or the gasoline and successfully doing so, we have shortened up the target from 2030 to 2025 because we will be able to reach that target by 2025 itself. Okay, the National Policy on Biofuels says the following things. First of all, it classifies certain biofuels. First of all, it says that there are two types of biofuels. One, from the traditional techniques, the first generation biofuels, these will be called as basic biofuel, and national policy will be focusing more on that. But we will also try to develop technologies to harness the advanced biofuels that are coming in the form of second generation, third generation and fourth generation biofuel. So the first thing it done was categorization. Second, to have a blending target of 20% blending by 2025. It also set a national biomass repository. It also set institutional mechanism for coordination. This is the National Biofuel Coordination Committee, which also comes under the Ministry of Petroleum and Natural Gas. Such question can be asked and manipulated in prelims examination, so please be aware of them. And then if we observe the trend of ethanol blending in India, can you also see the rising trend? This you can use in your mains paper, how it has risen in the last 8 years thanks to this particular policy. And can you also see the distribution of the ethanol from various feedstock? So currently, and this question can again be asked, this question, that which particular feedstock forms the largest contributor of the ethanol generation in India, and that is bee molasses. Molasses that is generated from the fermentation of sugarcane juice. So bee molasses, as you can see, the purple one, forms 61% of the total ethanol generation in India. And then as you can see, the sugar syrup, the sugarcane syrup, which recently has been said by the Ministry of Consumer Affairs that it will not be put to use in this year, that actually has formed the second largest percentage. And then there is the third largest one, that is surplus rice coming from the godowns of Food Corporation of India. So kindly look into this one using your handout, which is available in the description box, and analyze these trends and charts as well. Now, coming to the prelims perspective, and here we will talk about the oil cartel, that is the OPEC plus. This is a news because Russia and Saudi Arabia has called for all the OPEC plus members to join the agreement to put an oil output cut in order to safeguard against the inflationary trend, in order to give them more advantages in the oil market. Now see, OPEC countries have already made an oil output cut in the previous week. Now, OPEC Plus has been called upon by Russia and Saudi Arabia to do the same. Now, let's understand the difference between OPEC and OPEC Plus. So, first and foremost, what is OPEC? This is a permanent intergovernmental organization of the major oil exporting countries of the world. This oil cartel is very important to understand or to manage and balance the overall oil exports or oil trade that is running across the world, because they are responsible for 44% of the global oil production and up to 81.5% of the world's oil reserves, the proven reserves, are located with them. So therefore, this is very powerful oil cartel. Now let's talk about the formation. So now, in order to counter the oligopoly of the Anglo-American oil companies, the major countries that were exporting, major oil exporting countries came together in the Baghdad conference in the year 1960. Kindly remember the year. 5 founding members came together. This was Iran, Iraq. Surprisingly, both Iran and Iraq sat together along with Saudi Arabia and Kuwait and Venezuela. So all of the 5 came together and formed a cartel in order to regulate and manage the oil prices across the world. They were further joined by the other countries, and the headquarters was in Vienna, Austria. So kindly remember, while none of the country has got its place, none of the OPEC country lies in Europe, but its headquarters is in Austria, which is in Europe. So its headquarters is in Vienna. Now, why is it important? We have already understood. Now let's understand some of the important facts as well. Now see, when it comes to OPEC, it has got total 13 countries. 13 countries in total, but you need to be clear about some of the things which are very misleading. So first of all, Ecuador and Qatar, though have been highlighted in many maps across the Google, across multiple coaching platforms, please be careful that Ecuador and Qatar are not a part of OPEC. They have withdrew. So all the other countries are the part of OPEC right now. And what about Russia? Russia is not a part of OPEC. Russia is a part of OPEC plus. Therefore, when Russia and Saudi comes together, they are calling the OPEC plus countries and not the OPEC country, because for OPEC only Saudi Arabia was enough. Okay. So second thing is, all of them have one thing in common, that they trade a particular quality of oil. This is the Oman or the Saudi quality of oil, which is also known as the Basra light, the Basra grade of the oil, which is high in sulfur content. There are other 2 grades which are more environmental friendly. For example, the Brent crude oil, which is more prevalent or which is traded in Europe. It is more sweeter as in it is not having that high sulfur content. And then there is also the Texas grade oil, which is spread in the market of USA and Canada. So this is also more sweeter. So when it comes to the amount of sulfur content, the first is Basra light, then there is Texas, and then there is the Brent crude oil. Okay. Now let's talk about the larger organization comprising of not just the OPEC members but also the non-OPEC members, about 9 of them. So there are total 13 and 9, that is 22 oil exporting countries who come together, meet regularly to check and decide that how much crude oil should be sold on the world market. Now these countries, or this cartel, which is more broadened up, is more important because it controls not just 44 but now 50% of the world's oil market. So this was about OPEC and OPEC plus. What are the OPEC plus countries? You can have a look, but the most important ones are Mexico, that you have to note down, and Russia. Russia, Sudan, South Sudan, Mexico, these are the important members of OPEC plus. It can be used by UPSC examiner to have or to make you perform elimination in the prelims question. So kindly take a note of it. And then finally, we will read about Pompe disease. Pompe disease, that is a very rare genetic disorder which is in news because India's first Pompe disease patient, Nidhi Shirol, has recently passed away. So thereby we will read about what is this very rare genetic disorder. So first of all, to understand Pompe disease, let's understand what is glycogen. So what happens, whatever carbohydrate you consume via your roti and chawal, etc., all of that gets eventually converted into glucose, which provides energy to your body. Therefore, you are consuming food. But in order to store this energy, a different molecule which is rather of complex nature, more complex than the glucose molecule, which is a monosaccharide, and less complicated as compared to the carbohydrate, which is a polysaccharide. So a glycogen molecule is formed. Glycogen is basically the reservoir of energy in your body. Now glycogen is mostly required by the muscles. So whenever you move, or because there are so many motor movements by the muscle, they require enormous amount of energy and they derive it using glycogen. So 3/4 part of the total glycogen in the body is actually stored in the muscles only, in the muscle cells only. Why is it so? Because if it did not happen, then muscle would require the glucose or the glycogen to be taken up from the blood. And whenever you would do any intense exercise, any high intensity activity, then eventually all of your blood glucose will be sucked up and it will eventually lead to you fainting down. So therefore, in order to prevent against this, our body has a mechanism where most of the glycogen, the reservoir of energy, is stored in the cells, majorly in the muscle cells. What happens? This glycogen, whenever we want the energy from it, it gets activated by an enzyme. Glycogen that is present in the cell gets activated by an enzyme, and this enzyme is known as the alpha glucosidase. Alpha glucosidase is actually enacted by a gene. It is eventually triggered by a GAA gene. So this alpha glucosidase is called as GAA and it is triggered by instead a gene. So what happens? Because this gene is present, therefore this enzyme will be triggered and this enzyme will eventually break down the glucose or glycogen, which will break down into glucose, and glucose will give you energy. So this is the chain which follows. Now what happens if due to some genetic disorder you lack this gene? Then what happens? This glycogen will not be able to break down. Therefore, accumulation or storage of the glycogen will take place inside your body and you will not be able to get the energy and you will also not be able to move your muscles very frequently. Now, this is also thus known as the glycogen storage disease type disorder, which was named after the Dutch pathologist J.C. Pompe. So it's named as Pompe disease. And it is a very rare disorder because it is found only 1 in 40,000 to about 1 in 3 lakh births. It generally affects during childhood only because it is a genetic inherited disorder or a genetic mutation disorder. So what are the effects? The effects would first of all be on the muscle movement. So muscle weakness will come, both the skeletal muscles and the respiratory muscles, because the respiratory muscles is also tense due to accumulation of glycogen. What will happen? You will find difficulty in breathing. So therefore, difficulty in breathing is also observed, also because muscles are not moving in coordination with the body. Therefore, the motor skill development of a child will also not take place, and also the bones will also get weakened because of the coordination and the help and the strength provided to them by the muscles. So these were the effects. What is the diagnostic? Right now, there is no treatment available, but there are certain diagnostic. First, in the form of blood test, where some enzymes will be delivered in order to check the the further deficient enzyme in your body, and the second would be the genetic testing in order to check any mutations in your genes. There's no cure, as I've already told you, but what is available? Management therapy is available in order to delay the death, or in order to delay the responses, the bad responses from the body. So for that, enzyme replacement therapy is performed, which is very expensive in nature because this is a very less researched disease. It is very rare in nature. So this enzyme is particularly replaced so that we get the enzyme which is able to break down the glycogen in the body. So this was about the Pompe disease discussion. I hope you have enjoyed today's session. Thank you so much. Have a great day.